Good afternoon, good morning, good evening. Welcome. Not legal advice. Like, subscribe, share, comment, do anything. Nice to have you here. Nice to have you here anytime. Today I wanted to give you a preview. So little JR and I, mini JR, are doing a live stream coming up on Sunday night, 6:30 Eastern Time. One of the topics we're going to discuss is Sorrento Therapeutics and some changes in that. And I wanted to kind of briefly go over those to kind of give you an outline of what's going on. But before that, of course, I used to think I was indecisive, but now I'm not so sure. Anyway, Sorrento Therapeutics. Sorrento Therapeutics was a company, its subsidiary Skylex or Silex, in the oncology cancer drug theater. They ended up in some problem. They had to file bankruptcy because of a liquidity issue. They got naked shorted. While they were in bankruptcy, they filed Chapter 11. While they were in bankruptcy, they were able to persuade the bankruptcy judge in Texas to require the brokerages who were involved to disclose their share positions. When they disclosed their share positions, they determined that there was an excess number of shares. The court determined there were naked shorts, and that's what specifically the language that was used. The court entered in a temporary restraining order stopping further shorting and some other restrictions. There was a bunch of back and forth litigation. The temporary restraining order was continued, and then all of a sudden a motion was filed a few days ago where the debtor, which in this case would be Sorrento, along with the creditors and equity committee, and it would be for the benefit of the naked shorts, submitted a motion to the court saying we are going to offer shares to the naked shorts, or the holders of naked shorts, or those who come forward. Will offer them the ability to buy shares just to cover only, and if they do that and come clean, then they get a full release. We will come after them for the naked shorting. It doesn't go beyond naked shorting, by the way, just naked shorting. So that was sent out, and it was interesting because I was within the bankruptcy, and there were other discussions, but that was the submission. And then today we saw that the court had signed the order, so the order signed was that the parties can go forward with this transaction. So the way the transaction would be set up, if you're a naked short, and if by the 27th of July you come forward and with all the naked shorts that you hold, you go either into the public market and buy those shares and cover, or go directly to Sorrento and buy them directly from them. Now, as an aside, there was a recent, and I think it's connected to this, there was a recent offering by Skylex of approximately 13 million shares, and those may be shares that the shorts might purchase in part. And I don't know how many more shares above 13 million they expect. I don't know what the price action they expect on those shares. The price action is that they start, and so we have a limited amount of time. So today's the 21st. I don't think that this has gone, well, maybe it's gone into effect today, so maybe they could start buying today. But they have to do it by the 27th. It's 13 million shares. The average daily volume is just going to be a trickle of that. So it'll be influential on the stock price, not financial advice. But if they have to go in and buy the stock, and I think I saw the initial price is basically today's price of Skylex, which was something on the order of 561, but not clear because there was reference to dilution. But let's assume that's what it was. Then if you're a short, you go in, you start buying it at 561, but if a whole 12 million others come in buying, that'll create a lot of pressure that will impact the stock price. Now, obviously, this is with an ongoing trading stock, so it might impact the outcome. But even if it wasn't trading, theoretically, the way this was set up was you created the opportunity and the market for the shorts to find shares only to cover, and that demand in part would affect the price. You could do it where the price was fixed, and in part that will happen if in the Sorrento matter, if more than 13 million shares are required, then for those it'd have to buy them directly from Sorrento. And there's some representative of Sorrento that ultimately has the call on what that price should be, subject to but subject to input from the creditors committee and some other, but with very little impact from the naked shorts or the brokers. So it appears that there's a mechanism set up by this court whereby the naked shorts could cover, and we could have an only cover, and the stock will move to whatever the appropriate price is if 13 million shares is enough, and if more than 13 million shares are needed, or for other reasons, the price will be governed by a mechanism that the company controls and not the short sellers. So ongoing, now we have to wait and see what happens from here. So today's the 21st. So the order was today. The naked shorts have till the 27th to decide what to do. They are currently confidential. It'll be interesting to see what happens to the Skylex price over the next few days, not financial advice, if there's a buy-in and if that impacts the price. But more so, it will be interesting to see if this mechanism is used by others to deal with naked shorts. Are there more bankruptcies filed or encouraged or directed at companies who are engaging in improper practices? And just to clarify, most bankruptcies are voluntary, so the party that wants to file the bankruptcy is the one. But there are occasions and there's rules where an involuntary bankruptcy can occur. And in this case, it's really others who are filing a bankruptcy and forcing a company into bankruptcy. Could that apply to some company like Alpine or hedge funds off the rails or others? I think it very well could. That's kind of an alternative, or at least in my mind, I see it as an alternative to the receiver route, where you have a third party go in and run the business. That might be under state law. The rules might be more difficult. It appears that, at least in this court in Texas, that the bankruptcy judge has an ear out for not letting any shenanigans going on, and wants to at least resolve the issue of the naked shorts. Now again, for MMTLP or any other company, I don't know if this solution would work, and I'll discuss it with detail with JR, but it is another avenue, and it certainly was an avenue to find out what the naked shorts were, what the numbers were, and I guess what the identities of them were within the bankruptcy, and it seems to be effective because it may effectuate a resolution of that position. And on top of that, as I mentioned before, it doesn't clear the brokers, so the brokers are still at risk. They're not involved in this, so even though the naked shorts, and who likes this outcome in reality, in terms of the morality of it, but if people get paid, people get paid, but the brokers do not escape liability. This only applies to the naked shorts, and in this particular matter, only to the 27th of July if they elect to take advantage. So we will be watching this carefully, and I will be discussing it with JR. But again, in other naked short situations, may there be bankruptcy actions that might be available that might help retail investors get to the bottom of these facts. We'll wait and see, and we'll discuss it on Sunday night. Be well. Have a great weekend. Hope to see you Sunday night. Not legal advice.